Good morning. Welcome to Terra Firma Chambers 2020 Vision, Bringing Clarity to Planning Law. This is the fourth in our series of 2020 Vision. The previous outings included insolvency, the lasting effects of EU law and employment law. And those are all available, as will this webinar be, on our YouTube channel. Together with an earlier webinar that we did on local government in challenging times. So not only will the webinar be available, but the slides will be too. There's always a conundrum with slides as to how much to put on it. Both Alistair and I have chosen to put a fair degree of information on the slides. Don't worry, we won't be talking to them all. But if you want to look at the slides, they will also be available following this session. There is a question and answer function, or indeed a chat function. We'll be monitoring that during the course of the webinar. And if you want to ask some questions, we'll see if we can answer them, either picking them up during our talks or at the end. The talks, formal part, should last about 45 minutes, leaving ourselves with 15 minutes for anyone who has any questions, or an early bath if you don't. That's the outset. Slides will be available at the end, as will the webinar. Now, what we intend to cover today are four topics: interpretation of policy, which I'll deal with. Alistair will then take over and do a inner and outer house case roundup. Then I will deal with decision-making and the tilted balance. And finally, Alistair will come back and deal with heritage. And as I say, any questions as we go through. So I will deal with interpretation of policy. I only want to talk about two cases this morning. And the first case is Corbett and Cornwall Council. It's an English Court of Appeal case from April of this year. And I don't know what the weather's like with you, but the grey Perthshire mists are rolling in where I am. And this is very unlike the picture of the caravan park, which was at the heart of this case. The reason why the case is important is it concerns the application of what is in Scotland, section 25 of the Planning Act, that you make a determination in accordance with the plan unless material considerations indicate otherwise. It's the equivalent of section 38(6) of the Planning and Compulsory Purchase Act 2004 in England. And the circumstances of the case were that there was an application for extension of a caravan park in what in England is known as an area of great landscape value. It's not area of outstanding natural beauty, it's a designation below that. And the planning authority had granted permission for the extension of the car park. It conflicted with two development plan policies. Policy 14 was a strictly worded policy which said development will not be permitted in the AGLV if it causes harm. So it was unqualified. But there were other policies and development plan relating to tourism, particularly policy 5, which effectively encouraged tourism development and tourism related development. So the question was this proposal in accordance with the development plan or not? The planning officer in the planning report decided that it was, but at first instance, the judge took the view that because it conflicted with the AGLV policy, policy 14, that he should, there could only be one answer to the question about whether it accorded with the plan or not. And the plan should mean what it says, and it didn't accord with it. And so he quashed the grant of planning permission. The case went to Court of Appeal, And in the Court of Appeal, Lord Justice Liddell gave the judgment to the court. He held that Section 38(6), which, as I've said, is the equivalent to Section 25, can only be properly discharged if the decision maker establishes whether the proposal accords with the development plan as a whole. Now, that's fairly basic stuff, but on the other hand, it's worth remembering that in any officer's report or even reporter's report, there has to be a clear, or there should be a clear view taken about whether it whether the proposal accords to the plan or not. If, as was usual, Lord Justice Gladman went on that you get planning policies that pull in different directions, you have to make a judgment. And on the facts of the case before him, he held that the local planning authority had interpreted the policies correctly and struck an appropriate balance. So this was a case where you had essentially, where there were two policies protecting the environment, essentially one policy saying no development of any harm to the AGLV, another policy saying tourism development should be encouraged. The decision maker, the Court of Appeal held, had the ability to choose whether, notwithstanding conflict with one and accordance with another, whether there was compliance with the plan overall. He went on to say that he wasn't saying that if there's a breach of a single policy, that could never be capable of mounting conflict with the plan as a whole. And indeed, one can think of many cases where that is the case. If there's a breach of, say, a greenbelt policy, it's perhaps hard to think that it could accord with the plan as a whole. Certainly, greenbelt as one considers that in England. But it's a useful reminder that when looking at the policies of a plan, that they will pull in different directions, and that when you are interpreting whether the plan and whether a proposal applies with it or not, you have to look at the plan as a whole. The English Court of Appeal said there was no priority in the plan. The AGLV policy wasn't given any particular priority over the other policies, so that it was a matter for the planning officer, and she had made her decision correctly. So what are the implications of Corbett and Cornwall? Well, it's an argument that's likely to be pursued by applicants, i.e. that they are going to try and persuade planning officers and indeed reporters that simply because there's a conflict with a policy doesn't mean there's a conflict with the plan as a whole. It doesn't mean that argument succeed. It's a matter of planning judgment. And the court does emphasise, as do many of the decisions which both Alistair and I will be talking about, the importance of careful planning judgments in the context of public law challenges. Provided the planning judgment is made correctly, the chances of a successful planning law challenge are significantly reduced, because one thing the courts both in Scotland and England will not do is seek to second guess the planning judgment of the decision maker, whether that be an officer in a planning authority or a reporter on appeal. What it does do is reiterate the importance of the centrality in a plan-led system of making a finding and concentrating on whether the proposal accords with the development plan or it doesn't. And making sure that when you interpret the development plan, that you interpret it as a whole. As an aside, there was another policy in dispute in the case, which was concerned whether a general housing policy covered tourist accommodation. And again, as a good example of interpretation, the court held that the general housing policy didn't. It was dealing with normal housing. Policy 5, dealing with tourist accommodation, was dealing with other types of housing. So Corbett and Cornwall is, in my view, an important reminder of the approach that should be taken when considering planning applications in the development plan system. The second case I want to deal with deals with Samuel Smith. Now, other beers are available, but they won't be available yet for some time in Scotland, certainly not served as in a public house or a hotel. Samuel Smith are a well-known litigant south of the border, well-known, perhaps not quite as well-known as for their product, but they've taken a number of challenges over the years, and this one has got to the Supreme Court. The case concerned interpretation of the National Planning Policy Framework, which is the equivalent of RSPP, and provisions relating to the Green Belt, specifically whether the word openness included visual impact or not. i.e., when you were taking a view on openness, did you have to have regard to the visual impact of a proposal? It's quite a tied up English approach to life. I won't go into the detail of that too greatly. The case does indicate the consequences, particularly of Tesco stores and Dundee, that matters of interpretation and planning policy are for the court's application for the decision maker, and that there's been a deluge of challenges in England on interpretation of planning policy, which hasn't really yet been seen in Scotland, subject to the Gladman series of cases I'll come to in my second round. So the Supreme Court endorsed the approach in Tesco stores and Dundee and Hopkins Homes, and it reiterated the warning against over-legalisation of the planning process, which warning chimes with the speech, for instance, that the Lord President gave to the last Christmas meeting of the Scottish Planning Local Government and Environmental Law Bar Group. There's a concern in both countries about the over-legalisation of the planning process, and that comes across in many of the decisions that we'll be looking at today. So on interpretation of policy, it reiterated that the plans aren't drafted like contracts. They may pull in different directions. You're looking at the document as a whole and trying to understand what it means. And the third case I could have added there was that of Trump and Scottish ministers, which, whilst not dealing with planning policy, provided a useful endorsement of the approach in Tesco and Dundee, and applied even contractual case law provisions about how you interpret contracts to the planning field with certain caveats. The second point of interest in Samuel Smith was the consideration the Supreme Court gave to material considerations. You may recall that, as I indicated at the outset of this case, in Samuel Smith, the concern was, did they have to take into account visual impact when forming a view as to whether the development would have an impact on the openness of the Green Belt or not? And first of all, looking at it at a high level, the Supreme Court endorsed earlier judgments that just because a consideration is relevant and can be taken into account and can be referred to, it is not necessarily relevant to that decision maker, and that decision maker doesn't necessarily err if he fails to have regard to it. A material consideration only requires to be taken into account if the statute or policy expressly or impliedly requires it, or it's so obviously material that anything short of direct consideration would conflict with it. So coming back to the Green Belt example, visual impact was not, the Supreme Court found, so an express or implied material consideration when considering openness, nor, they said, was it so obviously material that you had to take it into account. So that in that case, the challenge, which was based on the decision maker not taking into account the visual impact of the proposal on the green belt failed. Another example is another English Court of Appeal case that was online this morning, Oxton Farm v Harrogate. It's not on the slides. It's 2020 England Wales Court of Appeal, case number 805, which is an indication of the output of the English Court of Appeal. They're on the 800th, over 800 cases already this year. That was a case about whether on housing land supply, whether ONS statistics were relevant to an issue on housing land supply. The English Court of Appeal said that they weren't expressly or impliedly required to be taken into account, and it wasn't so obviously material they had to be taken into account. So they weren't taken into account. So two important points to take from Samuel Smith's. Firstly, an endorsement of the approach and interpretation again by the Supreme Court. And secondly, a nuance in terms of material considerations, that just because something is a material consideration in planning law, which is a matter of law, there are a wide variety of material considerations, but a failure to deal with them in a decision will only lead to that decision being quashed if there are material considerations that are expressly or impliedly required to be taken into account, or so obviously material that they should be. So as a roundup on that, in terms of policy and approach, I think it's a useful summary, concepts and recent case law both in Scotland and England. On construction and interpretation of policy, the decision maker must identify and understand the relevant policies. Construction of a policy is a matter of law. Application of policy, once properly understood, is a matter of planning judgment. And that planning judgment will not be disturbed by the court. So that's my first part over, and I will now pass over to Alistair to deal with a case roundup. Just to remind you, any questions you have on any of the cases, please use the question and answer function, and the slides will be available at the end of the session. Thank you.
Thank you, James. I'm going to try and go through a number of cases very briefly, just to point out roughly what they're about. And if people want to ask questions at the end or find out more, then I think the best thing is to go to the case. The first case I'm going to talk about is Community Windpower against Scottish Ministers, which was the latest in a long-running battle in relation to a wind farm development. And the point here was it was an enforcement notice appeal against a condition that required the wind farm developer, at essence, to provide a fully operational alternative supply of water to private residences, either by connecting them to the public water supply or by connecting them to a suitable private supply. Now, it was quite a complicated case. In fact, Lord Brodie, in his judgment, paragraph 30, noted that brevity was not a feature of the appeal, it extending to some 26 pages and asking 22 questions of the court, which I think we can take from the terms of the judgment they didn't particularly enjoy. So perversely, I have tried to reduce the decision down to one slide, which we now put hopefully on the screen with my beautiful assistant James will do, hopefully. And as I said, the main point at issue was this condition for the developer to provide a fully operational replacement water supply. And the two options were via connecting to the public supply or a suitable private supply. Now, the developer's position was that that was their choice. They could choose either to supply it to the public water supply or a private water supply. They chose to try and connect to a private water supply, but when they brought that supply up to the boundaries of the properties of the objectors refused to allow them permission to dig across their land to fully connect the water supply. And the developer then appealed against an enforcement notice from the council, which said that they'd failed to comply with the condition. And I think the main points to be taken from the decision come out really at paragraph 50 of the decision, which highlight a number of matters. Firstly, that the role of the reporter in an enforcement decision is quite different from that of the planning authority who've decided to impose the enforcement notice. The reporter does not have the same amount of discretion, and it also points out that the previous provision that allowed, in the course of an enforcement notice appeal, for the developer to seek permission to be granted by the reporter or the Scottish ministers is no longer available. The only grounds of appeal in this case were that no breach of planning control had taken place, or that the matters that were required to take place in order to remedy that breach were excessive. And the point that gave the court the most difficulty was the suggestion that the nature of the condition gave the objectors a veto over the development, because they could refuse to allow the developers to fully connect the alternative water supply by not allowing them on their land. But the court decided that the role of the reporter was to interpret the condition as normal and take the words given in the condition and see whether it had been complied with. And it was clear that the reporter was correct, that a fully operational replacement water supply had not been provided. And so far as the complaint by the developer was that that gave a veto to the objectors, the route that the court suggested should be taken would be, rather than to say that no breach had taken place, it would have been better for them to either complain that the condition as drafted was unreasonable, which they expressly did not in this appeal, or to seek to have the condition varied by applying under section 42 for a different condition and then comply with that different condition. So in the end, the court found that there was no basis on which the developer could avoid the option it having chosen of being incorrect, and therefore they had been authors of their own misfortune. That's probably all I'm going to say about that, other than to point out that the court also said that the reporter's role didn't have the same discretion as the planning authority would have not to take enforcement action. The planning authority having decided to take enforcement action, the reporter just had to decide whether that had been complied with or not. So we then turn briefly to another enforcement notice appeal, which is the case of Cameron against the Scottish ministers. And this was a very brief case, but it related to a large property down in West Linton that had been turned from a residential home into a short stay accommodation. I notice on its website that it advertises only for hen parties and not stag parties. But this had been going on for some time, and it was the appellant itself that was claiming that the breach of planning had been for more than 10 years. The change of use had been for more than 10 years, and therefore it was too late for the enforcement notice to be applied to it. And it did so under reference to the use class order and the definition of house under class 9, and claimed that at any point that it had been changed from purely residential use to being used for holiday let accommodation had been in breach of the planning law, and therefore the breach had been ongoing for over 10 years. However, the court went back to look at the matter as a whole and decided that it's perfectly possible, and the reporter was correct, to regard the use on occasions as a holiday let to be ancillary to the main use of the property as a residential home. And therefore, it was only after the resident left the premises and it became entirely, or the majority of the time, used as a holiday let that the breach of planning control took place. And it was clear from the facts that that was less than 10 years ago. Therefore, the enforcement notice was valid, and the reporter did not have to identify a precise date on which that had taken place, as long as it was less than 10 years ago. So that's a fairly straightforward case. I don't have anything more to say about that. The next case is a slightly unusual case of the City of Edinburgh Council against Scottish ministers. And this related to a Section 42 application, which, as people commonly refer to as an application to vary the conditions imposed on a planning permission. And this particular case related to an outland permission that was granted in 2003 that required the reserve matters applications to be submitted within 15 years. So that was coming to an end. So the developer sought to extend the period within which it could lodge detailed or AMSC applications, as they now are, by seeking a Section 42 application to change that condition. And there was a dispute between the developer's view and the council's view as to the extent of the implications of that. The council was of the view that that would lead to a new planning permission, and following the case of Pi, it argued that the possibility of having regard to more than just the terms or difference in the conditions would be open to it, and that the reporter should look at the wider implications of the site, given that without this change in condition or new permission, further development would not be possible. And they also relied on the case of Lambeth, which recently been decided. We'll come on to that again in a second, but perhaps go to the next slide, James. The unusual point in relation to this case also is that on service of the appeal, the Scottish ministers agreed with two of the grounds of appeal submitted by the appellant. Firstly, that the reporter had not properly explained his approach to a Section 42 application to show that he understood that it resulted in the grant of a new permission, which was completely separate from the old permission, and had not explained how he had dealt with the submissions that he should look further than just the terms of the conditions. Now, in relation to that, the appellant changed its mind on the morning of the appeal, and therefore there were far fewer issues to be decided by the court than had originally been thought. And the court indicated that the first and main issue would have been very quickly dealt with on the basis of the Lambeth case, which is probably worth just mentioning, because that's a case where the Supreme Court had to decide the effect of the equivalent of a Section 42 application in England in a case where a local authority had forgotten to reimpose the same conditions in granting a new application had been in the previous one. And the court took what might be thought as a fairly lenient approach to that and said that the grant of permission had to be read in the context of what had been applied for. And it was clear that the appellant had not intended to apply for anything different from the conditions it already had, other than the conditions that it was trying to change. And therefore, you should read into it that the old conditions had been re-implemented and required to be complied with in the new consent. However, in the City of Edinburgh case, the main issue of the extent to which one had to go further than just the conditions was different from the Pi case, because in this case, unlike in Pi, the original permission, the 2003 permission, had been implemented, and therefore it wasn't a question of no development if this application was allowed to go forward. And that's really what the court was referring to at this point in the decision. And it said it was a material consideration that the permission had already been implemented in part, and that could be taken into account when deciding how far the reporter had to look into the new issues. And then the other couple of points that were of interest in the decision, if we go over to the next slide, despite the council's complaint that the reporter hadn't made it clear what test he was applying, the court said that there was no need for him to set out the test or criteria he was applying in these circumstances, because it was relatively straightforward, which is slightly ironic given that the appellant and the developer were at odds as to how the reporter should approach the matter, and the ministers had conceded that point. The other 2 points perhaps of notice in the next paragraph 42 of the decision the council had a concern that the reporter had not properly considered whether or not to impose or to request a new Section 75 agreement in relation to the new permission, and whether it might be argued that the old Section 75 no longer applied if the new permission were granted. And sort of note at the end of that particular quote that the court said that if there is an issue about the continued application or interpretation of the existing Section 75 agreement, that can be resolved in due course. As matters stand, it remains relevant to the new permission, which tends to support or suggest that the court would find that the terms of the Section 75 continue to apply, even though it now relates to a new outline permission or planning permission in principle. And then the final point, a short point in relation to this case, but the developer had argued before the reporter that there was a shortfall in the housing land supply in the Edinburgh area based on the 2017 housing land supply audit, and the council had said that there wasn't under reference to the 2018 housing land audit. And we can see on the left what the reporter said about that. He, in the final sentence, appeared to say that the new homes will provide an important contribution to the council's housing shortfall, which tends to suggest he took that into account. And then on the right, we can see what the court said in relation to that, which is in stark contrast to its consideration of housing shortfall in other cases that James will come on to talk about. And perhaps just move on from that. And the final case from the inner house in this section is actually a case about contractual interpretation of missives, but obviously is an interesting one for planners as well. In this case, there were missives between Ramoyle and Scottish Borders Council, which required Ramoyle to submit a planning application by a certain date. Otherwise, the council, who are the owners of the land, would be entitled to withdraw from the agreement. And on the final day before the deadline, Ramoyle filled in an online planning application and submitted that to the council, but they didn't pay any fee or do anything else in relation to the application. And the next day, the council sought to withdraw from the missives on the basis that Ramoyle had not submitted a planning application. And as I say, it comes down to interpretation. And if you turn on to the next slide, it's really the difference between the sort of layman's version or the version of a natural meaning that might be taken from the missives of what was meant by lodged or submitted, and the more legalistic version of when a planning application is validly made. And at paragraphs 14 to 16, Lord Malcolm sets out the difference there, that in layman's terms and in terms of the contract, it could be seen that a planning application was lodged or submitted when the online application was made, but it would only be once the other requirements of the lodging of all the documents and the fee had been tendered that the all matters in order for a application to be validated and for the time limits within which a council required to determine the application would start to function. I don't know if I just want to flick through those two next slides, James. And then finally, just because we don't want to feel that any of the outer house judges are being discriminated against, very quick mention of two outer house decisions. The first one, Energy Contour against the Advocate General for Scotland, is just an example that the 3-month time limit for lodging a judicial review is not absolute, unlike the time limit for lodging a statutory appeal under the Act. There can be circumstances in which it's excusable to have lodged the judicial review more than 3 months after the date of the decision. That involved a policy of the Ministry of Defence in relation to a detection area for nuclear activity. The policy itself went back to 2005. The applicant didn't become aware of it till much later. And even then, they had another route which they tried to follow before raising judicial review proceedings. And in the circumstances, not least because there was no prejudice to the Ministry of Defence, Lord Tower allowed that judicial review to proceed, notwithstanding that it was over 3 months from the date of the decision. And finally, the last case is Bridges Antonine against North Lanarkshire Council. And I put that merely in as an exception to the rule where James Finlay was not on the winning side in a case. That related to retail policies and protection of town centre. And perhaps the only point of note, although maybe of interest to those who want to know the details of these matters, is that the judge found that the fact that a planning permission already existed for a larger scale development on the site, that didn't mean that there didn't need to be consideration of the current situation for a smaller scale development on the same site. Its effect on the town centre also had to be taken into account. It couldn't be assumed that it would be allowed in those circumstances. So I'm afraid that's a very quick run through, and I have to pass back to James now.
Thank you, Alistair, for that roundup of Scottish cases. I meant to say at the outset that if you wanted a more in-depth roundup of English cases, and I'm going to touch on, I've touched on one or two, and Alistair's going to touch on one at the end on heritage. I can recommend a recent webinar from Cornerstone Barristers, who I'm involved with down south, on the 21st of May. Tom Grosgrove, QC, and Robin Green gave a very full roundup of English, mainly Court of Appeal, but also High Court cases and Supreme Court cases, available on Cornerstone's channel, and you will notice some of the slides bear some similarity to one or two that you're looking at today. Decision making and the tilted balance. Other brands of milk are also available, but my talk today is about 3 cases: Graham's Dairy, and then 2 Gladman cases. And it's the final Gladman case that's the most important. But the 3 cases, the ball started rolling with Graham's Dairies. And I'm just going to give you a brief update on that, or resume on that. It involves a housing site on the outskirts of Stirling, lying in the green belt. And the question was, quite a long-running case, if there was a shortage of housing land supply, did that provide sufficient justification for planning permission to be granted? Officers recommended grant on that basis. Members refused, went to appeal. By the time the reporter looked at it, a new local plan was hoving into sight, which should have dealt with the housing shortfall. So the reporter said it was a close-run thing, reading between the lines, but on the basis that the new local development plan will sort out the shortfall, and that's where decisions as to where that shortfall should be met should be made. I'm going to recommend refusal of permission. The application had been called in by Scottish ministers. They took some time to consider it, but by the time they came to consider it, it transpired that the local plan reporters had made a mistake, and there was still a shortfall in the housing land supply. Unfortunately, Scottish ministers didn't deal with that. It didn't consider the change of circumstances between the date of the report and the date of their decision, and it was quashed because the Inner House accepted that if there had been a shortfall, that could have been a significant change. 2 points to note. One is that the development was considered by the reporter to be sustainable, notwithstanding it was in the green belt. And secondly, the point to take away from the case is that the decision has to be made on the circumstances as they are, as close as possible, to the date of the decision, not the date of the report. And indeed, the court indicated that if a new material set of circumstances had arisen, by the time of the case, it would have only been fair to have given the main parties the opportunity to make submissions on it. Those are the ordinary points of the case. The interesting point came in paragraph 34 in perhaps a sentence that was overlooked, where the Lord President said that if there was a shortfall, that required a recalibration of the balance. And just in case anyone was any doubt as to what he meant by that, in paragraph 36, he went on to say that the tilted balance, which those dealing with housing and land supply will be very familiar, about which there's been a lot of judicial authority in England, would then have applied. But he didn't need to go further than that on the facts of the case, but that brought the tilted balance into the Scottish legal lexicon for the first time, as far as I'm aware. The next case was the first Gladman case that succeeded, and this was before the same bench, the Lord President, Lord Mingus and Lord Brady's, the same three musketeers who've decided all three of these cases. In that case, Gladman's, the main argument between Gladman and the planning authority was there a shortage of housing land supply? And one of the significant differences between them was whether you should take into account the previous undersupply in earlier years in calculating your 5-year housing land supply. There's no clear policy guidance on it. Different reporters have gone different ways, but Gladman's complaint was that this reporter hadn't grappled with the issue, had simply followed with what the council had done, and that wasn't good enough. And also she hadn't explained why she disagreed with other reporters in other cases. But importantly, in this case, she found the development was in any event not sustainable. The court concluded that her decision should be quashed because she should have grappled with the issue, the methodological issue about housing shortfall, and that she should have given reasons why she disagreed with previous reporters. As to the minister's submission, it wouldn't have made any difference because the development was not sustainable. The court held that the tilted balance might have applied, or would have applied if there was a shortfall, irrespective of whether the development was sustainable or not. That then led on to the third Gladman case. And just before we turn to that, I'll put up a slide which gives a brief reminder of, first of all, paragraph 125, which is if the trigger mechanism for when a housing shortfall will, 5-year housing land supply shortfall will trigger will pull the trigger that the plan is out of date. And then paragraph 33 of SPP tells you what happens if the plan is out of date. And it's in two parts. First part says where relevant policies in the development plan are out of date, the presumption in favour of development that contributes to sustainable development will be a significant material consideration. Apologies. And secondly, decision makers should also take into account, and this is the tilted balance, any adverse impacts which would significantly and demonstrably outweigh the benefits when assessed against the wider policies in the SPP. So it's not just a balancing exercise. The adverse impacts have to significantly and demonstrably outweigh, not just ordinarily outweigh, the benefits. Now, it could be said that paragraph 33 is slightly Delphic in terms. It's certainly not as convoluted as the equivalent English provisions in the framework. Originally in paragraph 14, from which the idea of a plan being out of date was first introduced either north or south of the border, and now in paragraph 11 of the up-to-date framework. But it is much simpler. In England, there are, Mr. Justice Holgate in a case called Monkhill, right at the end of last year, determined there were 15 stages a decision maker had to go through in order to apply the tilted balance correctly in England. There's a much shorter, more succinct approach in Scotland, but there was dispute. And the dispute was about whether the tilted balance could apply if the development wasn't otherwise considered sustainable. Harking back to the two cases I referred to, in Graham's Dairies it was sustainable, in Gladman it wasn't. In this case, the reporter had dealt with the appeal, found there was a shortfall, but because she found that the development was not sustainable, i.e. one that would contribute to sustainable development, she did not, and it's very clear, she didn't apply the tilted balance. The decision was quashed. In essence, the court determined that the shortage of housing was a significant material consideration and the tilted balance applied, and that that should happen irrespective of whether the development was considered sustainable or not. Two other important points I'll refer to, but then I won't deal with in any detail. The Inner House also identified that the proper housing target is the housing land requirement, not the housing supply target. Now, this is perhaps a concept for housing supply geeks, but the importance is that the housing land requirement is an inflated target by virtue of provisions within the SPP, usually somewhere between 10 and 20%, and so that it's a more difficult target to reach. But the court said on the wording of SPP, paragraphs won't bother you with today, you're looking at the housing land requirement. And secondly, the Inner House confirmed that the reporter is required to make a broad assessment of the seriousness of shortage in any case, i.e., as the court put it, how much the balance tilts will depend upon the seriousness of the shortage. So there are three important paragraphs from Gladman and Scottish ministers. And the questions that have arisen, and I've got one that David Bell kindly submitted before we started, which I'll come to at the end, is how does, the real questions are, how does this, what's the decision-making process that has to be gone through? And I've highlighted in three of the extracts from the opinion of the Inner House, again given by, in this case, by the Lord President, who gave it in Graham's Dairies, sitting with Lord Mingus and Lord Brady, that application, in my mind, this is the most important point to take away from the case, application of the tilted balance is part of the equation for determining whether development is in overall terms sustainable. Now, just pausing there for a moment, part of Gladman's argument was that if the tilted balance only applied when the development was sustainable, it wouldn't really have any effect, because if the reporter finds the development sustainable, it's almost inevitable that permission will be granted. So applying the tilted balance is just speeding the decision on the way to approval. What the Inner House has said is that when you're determining whether, looking at the paragraph 29 factors about whether the development is sustainable or not, you have to apply the tilted balance to that. And that comes over from paragraph 46, which I've put up in full. I'll just concentrate on the passages I've highlighted in bold. Whether the court said it is a sustainable development is another question. That is one for planning judgment, but it involves use of the tilted balance. And then moving to the end of that paragraph, each factor will play a part in the determination of whether overall the development is regarded as sustainable. So it's not suggesting new factors in the test, but you don't have a straight line approach to whether the development is sustainable or not. You apply the tilted balance. And lastly, in paragraph 47, the question the court set for reporters and planning officers, because this is important to bear in mind that this doesn't just deal with cases on appeal, it deals with cases before planning authorities, is that the question is whether the adverse impacts, the other policies and development plan, significantly and demonstrably outweigh the benefits in terms of housing shortage and economic gain. So three questions might be said to arise. Are the floodgates opened? In my view, no, because the Inner House was concerned to say that the matter was a question of planning judgment, and that's still for the reporter or for the decision maker. They've got to apply the correct balancing approach, but what weight they give to the factors in that balance is a matter for them, and the English courts have made that very clear. Secondly, how does it apply to other forms of development? Well, it's not as straightforward as housing shortfall being a material consideration, but if the plan is out of date, or policies are out of date, or similar triggers applied so that paragraph 33 is engaged, then the tilted balance can apply. And wind farms are a classic case where it's been applied in the past. Third question, when a policy is out of date or irrelevant, that is a matter on which there are many authorities in England, which I don't have time to go through today. It's out of date if it's over 5 years old. If there are no relevant policies, that effectively means what it says. So coming to David's question, which I alluded to earlier, I've put it up there, I'll just read through it. In a situation where a development plan is more than 5 years old, is the approach now that the tilted balance applies as first immediate step? And it's not necessarily to establish if a development is sustainable or not to enjoy the tilted balance, but by also then assessing the development as per wider considerations, the 13 principles and outcomes, that's from paragraph 29, a development's effects could be judged to be so significant they outweigh the benefits. If that's the approach, what does significant and demonstrably mean compared to the more standard planning balance? Well, coming back to the, go right back to the first slide, my answer to that is, well, on the wording at the moment, it would appear that the tilted balance has to be applied when you're determining whether or not it is sustainable. So it will make a difference, but what difference it will make will be down to the planning judgment of the parties concerned. So we'll take any further questions on this at the end, but can I just give a plug? Craig Welton, who was my instructing agent in the case, and I are going to spend a whole hour dealing with Gladman and the tilted balance next Tuesday, 7th of July, for a webinar. So do sign up to that if you want to hear more. We'll be concentrating on housing land supply, but not wholly housing land supply. And lastly, but not least, just to remind you that the time for appeal has not yet expired. It'll expire at the end of this week. And one doesn't know yet whether this matter will go to the Supreme Court. It's certainly, in our view, a matter of significance. So over to Alistair. We're running slightly over on our time estimate. We should have still have some time for questions. But Alistair's going to deal with two cases on heritage first. You need to unmute yourself.
Thank you, James. Yes, very briefly, two cases, one from Scotland, one from England in relation to listed buildings. The first, fairly straightforward case, Liddell against Argyll and Bute Council. The complaint here by the owner of a listed building was that the reporter failed to properly take into account the effect of the proposed development on the setting of the building. And in particular, there's criticism of the reporter, and I'm not sure, in fact, I know this is not an actual photograph of the site visit, but the complaint was the reporter never actually visited the listed building, but only got halfway there from the proposed development that was 1.5 kilometers away. I've set out in the slides, but I won't go through them, the relevant section of the Listed Building Act and the comments in relation to the setting of a listed building. But put shortly, the court found that the reporter had acted reasonably in not going to the listed building. That was a matter for the reporter, whether that was required. The reporter had concluded that the proposed development wouldn't have an effect on the setting of the listed building. And in doing so, if we skip 2 slides, they just reaffirmed 3 general principles from the Catesby Estates case. Firstly, that the decision maker needed to have an understanding of what the setting was, even if it was difficult or impossible to delineate exactly what the setting was. They must have an idea about what they were assessing the effect against. Secondly, that there was no single approach to identifying the extent of a building setting. that was a matter for planning judgment. And thirdly, the effect on a particular development, again, on the setting is a matter for planning judgment. And going over the page, the usual conclusion that in the absence of a clear error of law, the court should not intervene. The court should respect the expertise of the specialist planning inspectors. So that was just a very short case in Scotland in relation to that. And then finally, a case from the Supreme Court, Dill against Secretary of State. And this was in relation to whether the picture on the left is a building or not, because it was listed in the listed building list. Unfortunately for the owner, or the former owner of the two finials, he had sold them to an overseas purchaser, and they had been removed from the country, at which point the local planning authority became aware of this and served an enforcement notice or a breach of listed building consent notice, and the owner opposed that. And if we move on 2 slides, we can see the terms of section 1.5 of the Listed Building Act. And we can see there that in the Act, the listed building means a building, which is for the time being included in the list. And then it's extended potentially at A to include an object or structure fixed to the building, or an object or structure within the curtilage which has been there since before July 1948. In this particular case, the actual urns had been moved on a number of occasions, at least 3 times since 1948. So that final part of the section did not apply. And the courts, up until the Supreme Court, had, however, found that the listing in the listed building list was determinative of whether or not the items were listed buildings, and it was not open to the owner to claim that they were not. But the Supreme Court decided otherwise, especially in view of the fact that it is a criminal offence to remove or demolish a listed building. They said that all defences should be open, including to argue that the items were not actually buildings. And having decided that, they were going to remit the case to the Secretary of State, but they nevertheless went on to give some guidance on how to assess whether or not something was a building. And we can see in the penultimate slide there that they recommended using the criteria from the Skerritt's case that are used in relation to buildings generally in planning law contexts, of whether the items were of sufficient size, permanence, and degree of physical attachment. So while the Supreme Court didn't decide these matters, they did give some guidance about how the Secretary of State should go around assessing that. And they also did point out at the very end of the case that perhaps it wasn't necessarily the greatest use of resources to look too closely into this matter. But it does give some general guidance about how these matters should be approached. And then just at the end, I've just given that picture again because it was of some interest to me that when I Googled John van Noest, the sculptor who had produced these, that the one on the right is actually not by him, as most people know, but by John van Noest the Younger, his nephew, and it is entitled Sculpture of an Advocate or Preacher. And I think one ought to know which one is asking for to see what degree of trouble we're in before you ask for a sculpture to be made. But the advocate in this case, no doubt, bears a close resemblance to Mr. Finlay.
So, thank you, Alistair. I've enjoyed being your assistant throughout this morning, notwithstanding the points coming my way. We have 3 questions, and unusually for a webinar, certainly in my experience, they all come from Queen's Counsel. But I take that as a sincere flattery that Alistair and I have been questioned by other Queen's Counsel as to the approach to the case. So I'm going to take the first one, which comes from John Campbell, where he says, and you can look at these, I think they're on the question and answer. Given the strong emphasis in court's opinions on the untouchable character of planning judgment and exercised by planning officer, committee or reporter, do you agree that a challenge to a decision which is said to depend on planning judgment is virtually untouchable? Put another way, what are the options available when you when a purported exercise of planning judgment is shown to have been predicated on incomplete or flawed understanding of the key facts. I won't read on. John and I were on the opposite sides of the Arden Capel case, and just in case anyone got the wrong impression from Alistair's slide, the planning officer who took the decision in that was very much not of the same figure, proportions, or even sex, if I can say that, as the man shown in the photograph. But John is right, in my view. The court's opinions, planning judgment is sacrosanct. If you can show an error of fact, and there's a case in England called E and the Secretary of State, which is an immigration case, if there's if a planning judgment has been exercised clearly on a misunderstanding of the facts, and you can demonstrate that, then that might give you an in to challenge the planning authority, because they will have taken into account an immaterial consideration, to use legal jargon. But absent such as that, if it's a question of planning judgment, the courts are very reluctant to get involved. The second question comes from Marcus Trinick, and I'm going to pass it over to Alistair because it relates to the Lambeth case. And so I'll ask Alistair to read that out, and then if he can pass it back to me for Marcus's last question.
Thank you, James. Yes, Trinick asks whether I think that the Lambeth decision is as dangerous as it appears, since we can no longer assume that the relevant planning history in a Section 42 case is limited to the permission varied under the Section 42 application, and this seems to give rise to unwelcome uncertainty. It makes reference to the Pioneers Aggregates case. And put another way, did digging a planning officer out of a hole, was that unwise? And I agree that I think this is a potentially difficult and dangerous case, and a potential difficult case is making bad law situation where the planning authority had clearly made a mistake and the Supreme Court was sympathetic to that and trying to help them out. But it does make it much more difficult to know what the situation is. And one has to bear in mind that ordinarily, if one looks at a planning application and the consent, you would expect to be able to tell from the consent what was required. And a potential purchaser of a site would look at the planning permission as granted to see what conditions were applied to it. And it wouldn't necessarily want or have to go back to the application to then reinterpret the conditions. So I do think it is potentially dangerous imposition or encroachment into a question of certainty to try and help out this particular situation. And it tends to suggest that matters are far more open to interpretation rather than just looking at the one determinative document.
Yes, no, I would agree. And the other point to note for those that are considering Section 42 applications is that the English and Welsh Court of Appeal has recently determined in a case called Finney that you can't use Section 42 if you're to change the condition if what you're then doing is conflicting with the description of the development that has been granted. It's a moot point as to how far you can get around that by making non-material change. That's another matter, but the Lambeth decision is problematic very much for the reasons that Alistair's just indicated. So I think we have one more question left, and that's Marcus Trinick to me. Where does Gladman take the Section 36 Electricity Act cases where the development plan is up to date, but in circumstances where Section 25 does not apply? Paragraph 32 of SPP cannot apply because it depends on development plan primacy. So how do you apply paragraph 33 and claim a tilted balance? Well, Marcus and I are old adversaries on wind farm cases, but my view is that because the Electricity Act decision does not see a place to the development plan, then the mechanism within SPP for either giving additional weight to something or applying a tilted balance is very difficult to apply, because they're part and parcel of a mechanism where primacy is given to the development plan, and they're trying to rebalance matters in particular cases. So I think that the tilted balance and the presumption in favour of sustainable development, insofar as it's concerned within SPP, is difficult to apply in Electricity Act cases. If the development is sustainable, that's clearly a bonus point for it. The development plan is out of date. You may give less weight to the policies, but the particular mechanisms for judging how you tilt the balance within a development plan-led system, to my mind, don't apply to the Electricity Act, because the Electricity Act is different. Anyway, that's the last question I'm going to deal with, and all I'm going to say on that point, other than to thank you all for bearing with us today. We've kept most of you for most of the performance. We've slightly overrun. Our apologies for that. As I say, the slides and the webinar will be available online shortly after we go offline today. And to thank you indeed for listening, and hope we will see some of you again soon in better times. Thank you very much indeed.